In this video, I'll be going over the 3 most important dates and deadlines that you have in your workers' compensation case. If this is your first time to my channel, my name is Dominic Celeste, the virtual accident attorney. I'm based in Palm Beach County, Florida, and I represent those injured on the job in workers' compensation and due to the fault of another in personal injury. This channel is all about answering your questions and giving you tips relating to workers' compensation and personal injury law. Now, before we get into the video, I have to show you this disclaimer, so just hold tight. And with that out of the way, let's get into the video. So as I said, there's 3 important dates and deadlines that you have in your workers' compensation case. The first most important date is what's called the notice requirement. And what this is basically that you have to report your accident or injury within 30 days of it occurring, or when you knew or should have known that your injury or condition was related to your employment. Now, here are a couple tips with regard to the reporting requirement. 1, you need to report it to your supervisor. Not a coworker, not a friend, your supervisor. 2, you need to do it in writing. And I don't mean on a piece of paper and handing it to your supervisor. I mean by something that you can keep, something that shows that they actually received it. Like, for example, by email with a read receipt, or the same thing with a text message and a read receipt. And especially don't just go and tell your supervisor or call them on the phone. It needs to be in writing. Now, calculating the 30 days out from an acute accident like a slip and fall, that's pretty easy. It's just 30 days from the accident. But where it gets more complicated are in cases like repetitive trauma or exposure cases. These are cases when you don't really know when the accident occurred. And that's why there's that second part of the definition that you have to report within 30 days of your accident, or when you knew or should have known that your injury or condition was related to your employment. Now, in those type of cases, usually that's when a doctor tells you. But a little tip here is that if you feel that your injury or condition might be related to your employment, you should tell your supervisor anyways, just to be safe. Now, the last 2 important dates or deadlines relate to what's called the statute of limitations, or abbreviated the SOL. The first statute of limitations relates to that you have to file a claim within 2 years of your accident. This is why it's especially important to hire an attorney, because it's a lot easier for your attorney to file a claim on your behalf than you to try and do it yourself. And the second statute of limitations date relates to when you already have an active workers' compensation case, and that you're getting medical care and you're seeing a workers' comp doctor. And what you're required to do is see that authorized workers' comp doctor at least once a year. But here's a little tip. I tell all of my clients, go to your authorized doctor twice a year. That way you know you'll never be in violation. This issue comes up a lot when you're released to what's called maximum medical improvement, or abbreviated MMI. And what this basically means is that your doctor doesn't think that there's any more medical care or treatment that's going to make your condition any better. And usually when this happens, the adjuster will send you a maximum medical improvement or release to work letter. And what this letter basically says is, if you want to continue seeing your workers' comp doctor, you have to pay a $10 copay. And oh yeah, in very small print, you have to see your doctor at least once a year to keep your case open. Now, I've seen some letters say, and some adjusters or nurse case managers actually testify, that they believe once you're released to max medical improvement, you're only allowed to see your work comp doctor once a year. But that's false. Don't let them tell you that. Don't believe it. Their confusion relates to the 1-year statute of limitations. But again, it's not that you're only allowed to go to your work comp doctor once a year. It's that you have to go at least once a year. You can go as many times as you want. But remember, you have to pay that $10 copay. And if you're interested in learning more about maximum medical improvement, what sort of medical care that you can get in your workers' comp case, or just what type of benefits that you can get in general in a workers' comp case, make sure you hit that subscribe and notification bell, because I have a video that I plan on releasing going over all of that. So what happens if you violate the notice requirement or one of the statute of limitations? Well, your case will most likely be denied. Now, if that happens, there are exceptions to getting around the violations. I'm not going to get into all those exceptions in this video, but one of the most common exceptions is that workers' comp never sent you the informational brochure or documents explaining your rights under workers' comp, like what the statute of limitations is and all of that. So to summarize this video, you have 3 important dates or deadlines in a workers' comp case. The first one is that you have to report your accident or injury within 30 days of the date of accident, or when you knew or should have known that your injury or condition was related to your employment. The second one is that you have 2 years to file a claim on your case, or you may be in violation of the statute of limitations. And the third is if you're seeing a workers' comp doctor, you have to see that doctor at least once a year or you'll be in violation of the statute of limitations. So as you can see, workers' comp law is very complex. This video has only scratched the surface of that complexity. And making sure that you abide by and do not violate these 3 important dates and deadlines will help ensure that you can keep your workers' comp case open. You can't do this alone. You need to hire an attorney who regularly handles workers' compensation cases, goes to court, represents real clients, reads case law, who knows what they're doing. Give me a call any time of the day or night. I have a 24/7, 365 receptionist. Go to my website and schedule a free consultation. Or you know what? Just text me, 561-935-3822. But that's it for this video. If you got value out of it or if you learned something, please hit that like and subscribe button. It really helps me out. Let me know what you think of this video, or if you have any questions, hit the comment section below. If you want to find out more about me, about my firm, about how to contact me or workers' comp or personal injury law in Florida, go to my website, virtualaccidentattorney.com. But that's it for now. Again, I'm Dominic Celeste, the Virtual Accident Attorney, and I'll see you in the next video.